Good morning. I am Judge Lambert. I'm presiding today over this appellate argument. Welcome to the 5th DCA Zoom oral arguments. Case today is 20-285, the estate of Caleb Timothy Eisenberg et al. Versus Smith Equities Corporation and Gerald Smith. Let me introduce the panel. Judge Eisnagel is on our panel, as is Judge Harris. Keep in mind that we are being live streamed on YouTube, whatever it is, YouTube. So just keeping that in mind as you make your comments or arguments. You'll see on one of the panels, the clock is there. Each side has 20 minutes. Appellant, we'll give you 5 minutes on rebuttal unless you tell us something different. I'll keep an eye on the clock for you. Let you know when you go into your rebuttal time. You just let us know if you want something more so they can set it accordingly. That being said, I guess we are ready to proceed. So, Mr. McCullough, you're the appellant. Go ahead, sir.
Thank you, Your Honor. Good morning, honorable members of the court. I am E. Timothy McCullough, appearing pro se, and as a counsel for the estate of Caleb Timothy Eisenberg, deceased minor child, and Thomas Glenn Conyers III, a severely disabled minor child. It should be noted at the outset that on April 30, 2019, Judges Evander, Lambert, and Harris denied a 57105 motion for sanctions that mirrored and incorporated the 57105 motion that is subject matter of this case and the basis for the January 24, 2020 second final judgment and the March 11, 2020 second amended final judgment, which the appellants seek to vacate. This is the third appeal of the lower court to this of the lower court's actions in this case. The first sought reversal of Judge Jordan's reversal of his initial denial of the appellate's motion for summary judgment. The second sought prohibition of lower court proceedings after divestiture of jurisdiction with final judgment on December 11, 2017. And this third one seeks to vacate the subject order granting sanctions. The appellates identify themselves as the children and the appellees as the property managers. The children's initial brief identifies dispositive bedrock principles of law supported by express statutory language and binding precedent. And because it seems to be one of the standard practices of opposing counsel to immediately say that things are too ambiguous, we have categorized these bedrock principles into 7 specific categories, although there had to be a judicial limitation because there were many more. The violations of law and ethics that occurred in this case resulted in a judgment without specific findings of fact against the deceased child and a handicapped child and their conscientious and respectful attorney that undermines the purposes of 57105 to prevent frivolous litigation. Nothing could dispel the notion of frivolousness, to the extent there is a definition of that term, more than an experienced trial judge, such as Judge Jordan, having to initially deny motions for summary judgment, and then asking for briefs on a legal issue. That was a very close call in this particular case.
Counsel, you're spending a lot of time trying to give us history. We understand about the case. I think maybe you should use your time a little more effectively and talk about what the specific issues here that would seem to be dispositive.
And that's what I was just getting to now, Your Honor.
Okay, well, let's go. It's your time.
Yep. The 7 bedrock principles law. The first one.
We'll just go straight to this one. In order to repudiate the agreement, didn't you need to return the $1 million?
Absolutely not, Your Honor. You have to remember, and this is something that I tried to express to Judge Jordan, and I tried to express to this court when we appealed his motion for summary judgment, is we weren't trying to repudiate the agreement. We were trying to enforce the agreement. And under Florida law, if you're trying to enforce the agreement, you have a right to just proceed to damages. But this is a very unusual release. An opposing counsel throughout this case in the trial court and also in argument before this court has tried to characterize this as a typical release where all rights and actions have been released from now until the end of the, it was not. It took 6 months to negotiate this release after a mediation. And during those 6 months, the main issue was how do the appellants preserve their rights in the event that we're being lied to.
Counsel, instead of telling us about the negotiations, which probably aren't, as best I can imagine, aren't dispositive, why don't you point us to the actual language in the agreement that you argue meant that you could keep the $1 million and still sue?
Happy to do that, Your Honor.
He's muted himself.
You're muted. Counsel, we can't hear you.
I must have accidentally hit my mouse.
There you go.
There was identification of the parties, and Smith Equities was one of the parties. So everybody was in privity, and that's one of the requirements for a warranty claim. Then there was a general release section. Then there was a specific warranty section that stated as follows. Gerald A. Smith works for Smith Equities as an independent contractor. Smith Equities Corporation, nor any affiliate of Smith Equities Corporation, has ever been involved in the management of the Russell Smith Trust, DBA Lake John's Motel Apartments. There is no financial or business relationship between Russell Smith Trust, DBA Lake John's Motel Apartments, and Smith Equities Corporation, or any affiliate of Smith Equities Corporation. Now, in addition to this express warranty, which we discovered 28 different categories of information post execution of this release.
Counsel, let's assume for the moment that that warranty was breached or violated, or however you want to describe it. Let's assume for a minute. Let's not go into that. Why didn't you have to return the $1 million?
I didn't have to return the $1 million because there's a remedy.
You muted yourself again, counsel.
And I apologize. I don't know how that is possible because I didn't touch anything.
No problem.
I apologize for my technological incompetence. Now, I just wanted to read this additional language in the release. It says, second party warrants neither Smith Equities Corporation nor its agents or employees participated in the management, operations, supervision, maintenance, or repair of the Lake John's Motel Apartment while acting within the scope and course of employment at Smith Equities Corporation. This includes hiring contractors or subcontractors to work at the subject premises. So that's a continuation of the warranty clause. You have to remember, this was drafted by opposing counsel, although in constant consultation with myself. Then finally, there is a remedy provision. Any violation, either express or implied, of these special provisions will void the entire settlement agreement between the parties. The warranty provision and the remedy provision are unique, practically. I've never seen them before in a release.
How does that provision you just read to us, explain to us how that means that you both get to sue and keep the $1 million?
Because as we've stated in our brief, first of all, in the last appeal to this court, and then in the briefs that we submitted to this court under the doctrines identified by Manzoni and under general Florida law principles, we have a right to either seek rescission, which requires return of the money, or we have a right to sue for damages. And in this case, that would have been the ultimate result had we been allowed to continue forward with this case.
Mr. McCall, you have had that $1 million without the settlement agreement?
I'm sorry?
Would you have received that $1 million without the settlement agreement?
Almost undoubtedly not, Your Honor.
Okay, so if the settlement agreement is void, why doesn't the $1 million go right back?
Well, first of all, But again, under the doctrine set forth in the Manzoni case and in other cases that we've settled, we have a right to sue for damages. There's nothing in this. What we were doing was
the damages. I mean, in theory, what were the damages for breach of those warranties that you read to us?
I think the damages would have been whatever would have been the difference between what we received and what we could have received. But the other thing you have to remember is,
well, that wouldn't that be damages for negligence? I mean, isn't that different than damages for breach of the warranty?
In this case, it's very unusual because in the breach of the warranty voids this release. And you have to remember.
Right. I mean, I feel like we're kind of talking in circles. Isn't that the problem here?
Well, I think that no one has identified any case that would require a return of the funds under circumstances like this. And who knows, maybe this is a case of first impression. But that's the reason.
Didn't you lose that already? I mean, you know, you spent 10 minutes now of this argument here, and it seems like your opponent has identified for you what's probably your best argument here, and you're going back over a case that was PCA'd last year, and you seem to have made these same arguments before that were unconvincing. But what?
Well, but first of all, the court has to realize that the release as a bar was never part of their 57-105 motions, nor their notices, and the 57-105 motion that's before this court now was filed 91 days after final judgment, which
seems to be your best argument that Mr. Cole kind of pointed out in his answer brief, that he's asking us to carve a narrow exception from the untimeliness rule. And that would seem, it seemed like your position would be we shouldn't carve that. And it's clearly more than 30 days after the December 11, 2017 judgment. So what do you think about his narrow exception argument in his answer brief?
I think it's totally, yes, it's totally untenable. There is no exception to 57-105, the SAIA case, or 1.525. There is no exception permissible. The bright line rule was established in the SAIA case. It was recognized prior to the SAIA case by this court in Wentworth versus Johnson. That is binding precedent. Those cases also recognize that there's no leapfrogging past the final judgment to extend the deadline. Even in cases where the court has reserved jurisdiction, such as SAIA, the court has said that there can be no additional time granted. 30 days is it, and they didn't file their motion within 30 days. Had they filed their motion within 30 days but after judgment, you have to look at how defective that motion was. First of all, it didn't state that the release was a bar. Second of all, it totally violated the bedrock principles of 57-1, the statute itself, and then also its principles, because it did not allow for any possibility of curing a defect, which should have been identified but was not. You cannot withdraw a complaint after the complaint has been dismissed, after final judgment. So there was no possibility for this attorney, as conscientiously as I believe I was in researching the law and researching the fact, bringing this case, having a very arguable legal theory to support it. Quite frankly, I think that there's still the possibility in this case of seeking declaratory judgment to see if the warranty and remedy clauses should be enforced. I don't think that's been disposed of, but the 57-105 motion, what never identified the bar, and also never allowed an opportunity for correction. And the one thing, the relief it asked for was to withdraw the appeal to this court. It didn't ask for the relief of withdrawing the complaint. So not only didn't it identify the ultimate grounds for the 57-105 sanctions, not only didn't it allow for a cure, but it had
in a way you could have cured it, right, by dismissing the appeal. I mean, in a way that I mean, essentially you would have, if you abandon the appeal, then that is for all time abandoning the complaint, right?
Well, but it's my position that they didn't even have a right to ask for that in the lower court. Only this court can make decisions about what is appropriate in seeking this court's jurisdiction. In addition to which, I firmly believe, and I believe to this day, that we had a right to bring these legal issues to the attention of this court and have a decision made by this court. And this court not only reviewed all the pleadings and looked at that case carefully, didn't grant any summary disposition, but granted oral argument. And we had a thorough, detailed discussion about this case. And the court issued a PCA. I think that during oral argument, I got a sense that this court felt that the money should have been returned. You know, and just quickly on that issue, they didn't receive the $1 million. A lot of that money went to medical subrogation claims and has been put into trust to support the crippled child. There was a small percentage of that was received. So
No, you received $1 million. It was spent in a fashion that you all deemed it had to be spent. I mean,
well, but it couldn't have been returned. It had already been paid to other parties. And was not in the possession of any one party that could have written a check and returned it. And it couldn't have been returned to this party because this party didn't pay it. The Smith Trust paid it, but not Smith Equities.
okay,
So
well,
we weren't doing
a rebuttal. If you want to keep going, that's fine.
I think I'll reserve my time to respond to Mr. Cole. Thank you, Your Honor, for pointing that out.
All right, thank you. All right, Mr. Cole, go ahead, sir.
Good morning, Judge Lambert, and good morning, members of the panel. My name is Scott Cole. I'm here on behalf of what we refer to as the Smith defendants, who Mr. McCullough has referred to as the property managers. And Judge Lambert, I want to quickly address your issue because I think those are the two issues on appeal, and the two issues are: can the court create a narrow exception under these facts? And we submit that the court should and can. And here's the reason why. Mr. McCullough is a lawyer. He's been practicing 30, 40 years. I don't recall exactly how long. And in this case, it's very unusual because he actually signed the release. And that was important to my clients that he signed the release because he was aware, and we wanted him to know because he's the grandfather of these children and the mother of the person, the father of the personal representative, and he has a vested interest and an emotional interest in this case. So we wanted him to sign the release as evidence that he was aware of what the release was for and the contents of the release. He then did this pre-suit investigation, which, as you pointed out, Judge Lambert and Judge Eisnagel, was disposed of in the first appeal, where he claims there was a violation of this warranty agreement. We had told him after the release was signed and the money was funded, we had told him multiple times, there's no violation of the warranty agreement and there's an ironclad release, you can't sue us. So what did he do? He went ahead and sued us anyway. And he is correct in his papers. We didn't file an answer in affirmative defenses. We filed a motion for summary judgment. And on the very same day we filed that motion for summary judgment, we filed a motion for sanctions under 57105. That motion for sanctions did not include language that the release was a bar to the claim, but it was filed in conjunction with the motion for summary judgment, which did, as Mr. McCullough has admitted, which did include that the release was a bar to the claim. And everybody knew that going in. The release was always an issue which precluded him from bringing the case, as well as there was no violation of the warranty agreement. We then had a hearing on the motion for summary judgment, and the trial judge said exactly what you said this morning, Judge Eisnagel, and what you said at oral argument, Judge Lambert, is that the release is the elephant in the room. How can you take funds under a release and accept the settlement proceeds and then try and repudiate it and bring a lawsuit against the Smith defendants? And I remember the oral argument very distinctly because, Judge Lambert, you may recall, this is one we did at Rockledge High School. So that's why it sticks out in my mind. And I recall you asking that question. Judge Eisnagel asked it this morning, and Judge Jordan asked it at the hearing on the summary judgment. The judge then said, look, I'm focusing on the release, forget all the other issues. And again, clearly, consistently throughout this time period, the release was the issue. The Judge Jordan then said to the litigants, I'm going to give you guys some additional briefing on this issue, and then I'm going to rule. That's what he did. Each side had additional briefing. He then granted summary judgment. Final judgment was entered December 11, 2017. And so from a factual standpoint, we believe, although the first motion for sanctions, which we did say at a hearing we weren't operating under, but if you look at the big picture, what occurred here, the release was always an issue. This is a seasoned attorney. He knew he couldn't keep the money and sue. He did it anyway. He was asked that multiple times throughout the case, not only in this court, but in the trial court. And he went forward anyway, costing my clients funds out of their own pocket. Because as he pointed out, insurance proceeds paid the settlement. Those proceeds were done. So he continued to sue.
Are we looking at, are we looking at the fact that there were proceedings after the judgments to investigate the trailer? Or is it, an argument here, it seems like you're really focused on the experience of the lawyer, the fact that, everybody kind of knew what the issue was, even though it wasn't stated in the 57105 letter. Which one is it?
It's both, Judge Eisnagel, and thank you for bringing that up. I just completed the first argument that, factually speaking, the release was always there. And from a legal standpoint, we're all aware, and I put it in the brief, that we're all aware that the Supreme Court and this court has set a bright line rule under 1.525. It must be brought within 30 days. However, as you pointed out, Judge Eisnagel, and the record does reflect that even after the final judgment was entered, there were discussions between the parties, and that's at 984 to 989 in the record, about what to do with the trailer. And if the court will recall, the plaintiff got a temporary injunction against the trust not to destroy the trailer. And the Smith defendants, don't destroy the trailer. So after the final judgment was entered, we were still, these negotiations have been going on since October. And so after the final judgment, December 12th and December 15th, there were still discussions between the parties about setting the inspection. In fact, Mr. McCullough, and one of the problems here is, in this case, is he takes inconsistent positions. And I say that with the utmost respect, but he takes inconsistent positions. One position is the final judgment is the end of the litigation in this case. And yet below, again, 984 to 989, he's saying he wants to inspect the trailer in January. So there is still activity going on. We had said, no, inspect the trailer by the...
Legally, what's the effect of entry of the final judgment on the temporary injunction?
Well, Judge Harris, and again, looking at the facts of this case, the temporary injunction ended by its own terms on December 6th, which was before the final judgment, which was 5 days before. However, my clients were facing a man who sued them when they never should have been sued, and he was threatening a spoliation claim. And some of those
the court continued to have jurisdiction after the final judgment. If there's a bright line rule that says 30 days following the final judgment, it doesn't say unless your opponent is a seasoned litigator. It's just 30 days, right? Where's carve out this exception for you?
And I'm sorry, Judge, I spoke over you, but I think I did hear your question. We think the exception is, although there was a final judgment, the final judgment was on appeal, there was still activity going on, and the 57105 was also directed to that activity. And you have to understand that the activity that was going on was the inspection of the trailer, when my clients were getting threatened with a spoliation case. And we've even heard today that there may be another declaratory judgment case coming down the pipe. So this is why, and this is never going to end. This is why it's important for my clients to have these fees.
So you might have an interesting sort of argument for why the rule should say something different than it does. But do you agree that based upon the language of the rule as written right now, that the rule as written does not contemplate any exception as you're sort of describing here? Wouldn't we kind of have to in some way rewrite the language of the rule or ignore the plain language of the rule?
Judge Eisnagel, the rule as written does state what you said it states. I would agree that it's clear. However, even though we had a final judgment on December 11th, there was still things occurring in the case. And we filed our second motion for sanctions addressing the release issues, and Mr. McCullough is incorrect. The second motion specifically addressed the release within 30 days of the order disposing of the right to inspect. And that's why we believe it's timely under that scenario.
Well, you actually served it, right? I mean, And the actual rule 1.525 talks about serving it within 30 days, because if I understand the timing, the order disposing of the motion for inspection was in January. Your operative motion that you can see in your answer brief is the March 14, 2018 motion. That's still outside 30 days, but the rule itself talks about serving it within 30 days. And it sounds like what happened, and correct me if I'm wrong, is you sent in February, you sent a safe harbor letter and probably sent the motion as well to opposing counsel. And then when he didn't do whatever, you filed the motion in March of 2018. Is that the chronology?
It is, Judge Lambert. That's the chronology. The motion was sent to Mr. McCullough February 21st, I believe. He actually responded early March, even though it wasn't served yet. And then we served it on March 14th. So you are correct on that scenario. But again, this case, and I'm not just focusing Judge Harris or Judge Eisnagel on that he's a seasoned litigator. This case has taken on multiple lives of its own. And respectfully, again, I believe it's due to the actions of Mr. McCullough. We have a case where it shouldn't have been filed. Spoliation claims were threatened. Now other claims are being threatened. My lawyers, as set forth in the record, were reported to the Florida Bar on several occasions. And these fees are important not only to show Mr. McCullough that he shouldn't have filed this case. And Judge Eisnagel, you asked him to point out where in the release, as Judge Lambert did in the first oral argument, it allows him to keep the money and proceed with the claim. And it doesn't. It clearly doesn't. You can't have both sides. You can't, what's the expression? I'm going to mess it up. As the Unabomber said, you can't eat your cake and have it too. I think that's what the Unabomber said. The popular expression is you can't have your cake and eat it too. And that's what's happening here. And he's taking inconsistent positions. And the court has the inherent authority, even though we did move under 57-105, admittedly, to sanction an attorney for bringing a case such as this. The trial court didn't find that. We did move under 57-105, and that was the basis for the sanctions. But we believe the sanctions are well deserved here. We would ask that the court affirm this by procuring affirmance, not only to have a deterrent for my client, because quite frankly, and I'm only bringing it up because Mr. McCullough got into it, it's highly unlikely, and we're all realists here, that the estate's collectible or Mr. McCullough's collectible. But we'd like it as a deterrent and to show that lawyers can't do this. They can't do what Mr. McCullough did here. And so for those reasons and the reasons we set forth in our answer brief, we'd like the court to find that sanctions are
Can you respond to the maybe you sort of touched on it earlier, but I'm not sure you really explored it fully, but the whole concept of 57-105 giving a party an opportunity to correct a problem or withdraw a pleading if need be. How does a safe harbor letter sent after the trial court loses jurisdiction and the case is on appeal, how do those two line up? How does somebody fix it once it's on appeal?
Well, as you pointed out, Judge Eisnagel, one way to fix it is to dismiss the appeal.
But I think the problem with that is that you can't. That's getting rid of the case altogether, right?
Yes.
You can't. In this case, at least arguably, right? They could have not just gotten rid of the complaint. They didn't need to get rid of it. They could have just returned the $1 million, and then maybe that they would have had a case that was not right, not frivolous, and it would have gone forward. So this could be a case where they could have corrected the problem instead of withdrawing the pleading. But I think the problem with just dismissing the appeal is the case is entirely over. You can't just return the $1 million and proceed with the case.
You're correct. And at that time period, admittedly, there was nothing that had been filed that could have been withdrawn other than the appeal of the case. But I wanted to point out again, these were very unusual circumstances. And we had threatened litigation over this trailer, and we've heard threatened litigation today, and it was an ongoing issue. And the timing of that was basically to say, no more. We want sanctions for what's occurred, and nothing else can be brought, essentially, other than the appeal can run its course. And Mr. McCullough is correct. This court did deny 57105 sanctions on appeal, and Judge Lambert was on that panel. But I think that if you look at the facts of this case and what occurred in this case, the litigants in this case, and what's continued to occur in this case, it justifies the sanctions as entered and the timing as which occurred below.
Mr. Cole, if you could talk a little bit about the purpose of the safe harbor provision 57105.
Well, Judge Harris, it's what Judge Eisnagel just referenced. It's to alert somebody that they're taking a path that's non-justiciable, and to tell them they need to get off that path or they're going to be exposed to potential sanctions down the road.
And what is it in this case that Mr. McCullough was asked to do during those 21 days?
Well, and Judge Harris, as I pointed out, he had nothing pending. Admittedly, he didn't, but it was filed at that.
Asked him to do is, in 21 days, we want you to indemnify the Smith defendants. 57105 doesn't require indemnification, does it?
Not to my knowledge, Your Honor, and I'm not aware of any case that does, Judge.
That's all you asked him to do. You said indemnify us, and then we recommend that you drop the appeal. That's really not the purpose of 57105, is it?
I would agree that the purpose is to have somebody withdraw a position they've taken. One of the things that we filed it at that time for was because we were anticipating litigation over this trailer. We're anticipating a spoliation claim, as was threatened against us in writing. We had a lawyer who just filed a claim that shouldn't have been filed, and that has resulted in multiple litigation, including, as Mr. McCullough said, 3 appeals to this court, wasting this court's time, the trial court's time, through 4 trial judges. And that's the reason it was filed then. And that's the reason why we're asking for a very, very narrow exception on these facts. And I will admit to the court, under a strict reading of the rule, as all 3 members of the panel have pointed out, it wasn't the 30 days, it wasn't served, and it's their safe harbor provision is not present at that time in this case. But again, I would just ask the court to look at the big picture here, look at the actions taken by counsel on behalf of his clients, look at what this case turned into, and look at what's going to happen in the future, which we heard here today. And if you look at the big picture, we believe it was within the inherent authority of the trial judge. Even though admittedly there was not technical strict compliance with everything that was necessary, we believe it was within the inherent authority of the trial judge to sanction Mr. McCullough and the estate. And we would ask that this court affirm the trial judge below.
Counsel, I guess last question here, and I understand this is probably a difficult question, but I'm going to give you a chance to answer it because that's why we're here. But what do you say to the thought that, well, had you timely filed the motion, and had you done it in accordance with traditional 57105 procedures before the final judgment and things of that nature, that this would be a lot easier case, right? But what do you say to the line of thinking that, look, the rule says what it says, the statute says what it says. Why isn't the Supreme Court or the legislature the proper entities to make these changes instead of the DCA? I mean, where is our authority to do that, to do what you're asking us to do?
Well, I think your authority is, and Judge, and I say I have a few minutes left. I want to answer your question first, but I want to address a key point which you raised, which I probably did not do a very good job of addressing earlier. I think the court does have the authority, although the Supreme Court has said there's a bright line rule, to find exceptions to any rule. I mean, that's why the law evolves, and we think there's a good faith basis based on this record only, and I admittedly haven't seen it anywhere else, to have the law evolve on these facts, and that's all we're asking for. But you brought up an interesting point. We did timely file a 57105. We filed a very thorough 57105. And it wasn't based on the release though, right? That is correct. And the big picture here though is it was filed the same day as the summary judgment. And everybody knew the release was the issue. In fact, during that entire August 30th, 2017 to December 11th, 2017 time period, and even before the case was filed, the release was the sole focus of the case. I shouldn't say sole focus. The release was the main focus, of the case. And that's why on these facts, we believe sanctions are warranted. And I understand what the court's concerns are. I appreciate those, but we believe that there should be sufficient, there's a sufficient record here to keep the sanctions in place. And hopefully the court doesn't have any more questions for me. If the court does not, I'll rest on our papers, rest on my answers given here today. And I wanted to thank the court for allowing us to appear by Zoom. I appreciate it very much. We ask that the court affirm.
Thank you, counsel. Okay, Mr. McCullough, you have 435 on rebuttal.
Thank you, Your Honor. I wanted to address the issue first that I'm taking inconsistent positions. The court issued final judgment December 11th, and the opposing counsel did not file a special action, which is required if you're going to try to extend the jurisdiction of the lower court. Didn't come up to this.
What about the fact that, for 57105 notice purposes, it does seem like, when you look at the record, it does seem like while the release wasn't mentioned in that first, the first motion, the first 57105, it does seem clear that everyone below knew or should have known that the release was a major issue here, right?
Well, no, and the release was tangential at the time that it was first raised by Judge Jordan, because opposing counsel had never filed an affirmative defense, which is required if you're going to raise a release as a bar. Judge Jordan raised that issue on his own, and he asked for legal opinions as to whether or not this release would be dispositive. We had discussion on October 24th, which is the day he initially denied summary judgment, and he's the one that talked about the elephant in the room. That issue, the release as a bar, was never contained in any pleadings. Now, in their summary judgment motion, they did mention it as a second issue, but they didn't even argue that issue at the October 24th summary judgment. All that they ever mentioned in their notices, their motion for summary judgment, argument, or in their 57105 motions was that the actual allegations in the complaint were false. And Judge Jordan ruled that they were highly credible, and that we had 27 categories of evidence to show, and that if it was just based on that, it would have moved forward. He's the one that wanted the issue of the release raised. He brought that issue up. And so, in my opinion, it's still a very close issue. But on December 11th, there was final judgment, and the old circuit judge's language of "go hence without a day" was used. And then we did nothing. 4 days later, they filed a motion to compel inspection of trailer. Prior to that, we had gotten an injunction, which expired as of its own language on December the 8th. So December the 8th, the injunction expires. December the 11th, we have final judgment. The case is over. It is closed. It's final. There's divestiture of jurisdiction. We honor that. We don't file anything. On the 27th, they go in to see Judge Jordan to present ex parte their motion to compel inspection of trailer. He turns them away. There's no order indicating what his rationale for turning away was. But then they proceed to have an ex parte motion presented in front of Judge Rodriguez, a newly assigned judge, asking that we be compelled to inspect the trailer within 30 days. I talked to opposing counsel. I sent them an email saying, I don't think the court has jurisdiction. They replied, we don't think they have jurisdiction either, but we're going ahead with our motion. And I didn't go. And I felt that all that I did was appeal it to this court and took all actions in this court to try to advance my legal argument that these express.
I mean, it's kind of an aside issue, but how would an inspection of a trailer interfere with this court's jurisdiction over the appeal?
The inspection of the trailer was not required by anybody. and no court at that point had jurisdiction to regulate it or to deal with issues about whether or not the inspection was being complete or was fair or anything. We had nowhere to go. And the only thing that could have been done at that point, in addition to appealing it, is to file a separate action, notice everybody about what was going on. They're the ones that started, in effect, a new action, and that they started two things. They started an action to compel inspection of the trailer instead of creating a special action, which was required by the rules of procedure. They didn't file their disposition form. Oh, I see I'm losing it. But we never took another action except to defend against the 57105 motions, which is what we did. And we were shocked that they were filed because they were filed so late. Thank you, Your Honors.
Okay, all right. Thank you, counsel. We'll stand adjourned. Have a
Thank
good
you.